Got a great program lined up today on artificial intelligence. Artificial intelligence is, as everybody knows, ubiquitous in pretty much all aspects of life, from automating manufacturing to helping at fast food restaurants. The treatment of artificial intelligence under the law is still being developed, catching up with the technology advances. We're fortunate today to have Professor Ryan Abbott with us today to discuss artificial intelligence and its treatment under the law. Professor Abbott is highly credentialed and is currently a professor and chair of law and health sciences at the University of Surrey School of Law and an adjunct assistant professor of medicine at University of California, Los Angeles. In addition to being a U.S. patent attorney and an MD, Professor Abbott is also a solicitor advocate in England and Wales, a fellow of the Chartered Institute of Arbitrators, and a mediator and arbitrator for JAMS. He is an avid writer, having published numerous materials on the subject of today's presentation, including the book, The Reasonable Robot, Artificial Intelligence and the Law, which was published in 2020 by Cambridge University Press. He has also written widely on issues associated with law and technology, health law, and intellectual property, and leading legal, medical, and scientific books and journals. Professor Abbott's research has been featured prominently in the popular press, including in the Times, the New York Times, the Financial Times, and many other media outlets. In fact, Managing Intellectual Property magazine named him as one of the 50 most influential people in intellectual property in 2019. His history and credentials are obviously impressive, to say the least. And with that, I want to turn it over to Professor Abbott for today's presentation. But before doing so, I'll just note, as Matt did, we'll have questions and answers at the end. So please put your questions in the chat box. Thank you very much.
Well, thank you very much, Ben, for that overly generous introduction. Thank you for not mentioning the student debt. And I understand that Ben is personally buying everyone attending today a copy of the book. So that's very much appreciated. And you'll have to follow up with him in the social hour on how to get that. I'm going to try and end, actually, now that we've gone 10 minutes, in about 35 minutes to leave a little more time for questions. Anyone like Virginia is welcome to interrupt, but with the slides going, I probably won't be able to see them. But off we go. As Ben said, AI is doing very cool stuff these days. This particular advance didn't catch a lot of public attention, but for those of us in the patent world, it was interesting that AI made by DeepMind, which is owned by Google's parent company Alphabet, dramatically performed other teams in an annual contest designed to predict the 3D structure of folded proteins based on their two-dimensional sequences. And a couple years earlier, an AI made by this company beat the world's best Go player, which is a traditional Asian board game. That was interesting for a lot of reasons, including because that was the last board game, traditional board game, that people could outcompete machines at. But playing Go isn't that useful of an activity. Predicting protein folding structure, however, it is an activity that is sometimes vital to drug research and development, and may be something that helps lead to the development of a new therapeutic compound. Since this time, DeepMind has made publicly available the three-dimensional sequences of a very large number of proteins, including most of those in the human body, in an open access way for researchers. And if end of 2020, when that happened, is too far back for you, a few months ago, a team at Google published in the journal Nature that they had developed an AI using deep reinforcement learning that could design a new chip floor plan in ways that took hours instead of months for teams of people, and that outperformed human-developed chips in all key performance metrics. Now, there are, of course, always people involved in the process at some level. We'll come back to that a bit. But chip designs are something that are protected by IP, whether patents, registered designs, or through sui generis protection methods. And it is very fast moving how much AI is now doing in research and development, none of which has escaped the attention of policymakers. So Britain was the latest to jump on the national AI strategy bandwagon. They published their report a few months ago with a plan to make Britain a global AI superpower in the next 10 years, which sounds vaguely ominous, but is going to involve appropriate governance frameworks, lots of investments, and trying to figure out exactly what's going to be required to do that. not only have countries decided that they all want to be an AI superpower, but some of them have realized that this is going to require new rules. Europe or the European Commission recently released a draft AI regulations, which are kind of like GDPR for AI. It's going to take probably another 6 years for these or something like these to come into force. But in the meantime, it completely prohibits certain uses of AI and provides a number of ex ante and after the fact compliance requirements for people using or developing high risk AI and fewer requirements for lower minimal risk AI. But it's important to have the right rules in place for AI. Of course, AI is already regulated, just regulated through antitrust and privacy and IP laws that may not have been designed with AI in mind. And these rules are important because AI can cause a lot of social benefit, and we want to make sure that it is doing so in ways that provide the most social benefit. And AI can cause a number of costs, from self-driving cars running people over to financial market and political manipulation. Elon Musk thinks AI may doom the human race, so it's probably something we want to avoid. And although these particular rules don't have much to say about IP, our IP rules are also vitally important to maximizing the benefits of AI. That at least was a finding from the US's recent National Security Commission on AI. Congress put this together in 2018. It was co-headed by Eric Schmidt from Google. And the gist of the 750-page report is there is an AI arms race. We're losing to China, and we need to start spending $32 billion a year on publicly supporting AI research, which is what we spend now on biomedical research. There's also a whole chapter devoted to AI and IP, which was fun and exciting for me, including my personal favorite topic, inventorship by AI, which we'll come to. But the gist of this was also that our IP policies are not only vital to our AI industrial strategy and to national industrial strategy, but even to national security issues. Now, AI poses a lot of very interesting challenges to IP, only some of which involves AI making traditional intellectual property sorts of things. And really, that's not such a new phenomenon. People have said that they've had AI making music and artwork since the 1960s. And in 1966, the Registrar of Copyright, Abraham Kamenstein, disclosed that the US Copyright Office had already gotten several applications that were released in part for computer-generated works, usually described as things that don't have a traditional human author. If you haven't listened to some of the early AI music, I have, and it's absolutely terrible. I'm sure it's impressive that we've gotten a computer to do these things, but no one would actually want to listen to it for fun. By contrast, if you go to the OpenAI Jukebox Initiative, you can hear music made by an AI that has been trained on existing or recently deceased artists who make music that kind of sounds like they made it. I mean, it's not great, but it's not terrible anymore. It's firmly mediocre. And this raises some very interesting issues, not the least of which is training AI on other people's music and derivative issues of copyright ownership and so forth. But one of the really interesting things about this, legally, socially, and economically, is it's one thing when an AI can make a song that no one wants to listen to. But if an AI can make music in the style of Frank Sinatra that people actually do want to listen to, suddenly it has a lot more commercial value. God forbid an AI could make a song like Katy Perry, but even better. And not only is AI going to be making music the way people do, but will be making it in new and interesting sorts of ways. So it will be making music for you in real time, personalized to your own tastes in music, perhaps personalized to your activities and your mood. This is a famous painting from a series of paintings done autonomously by AI in the 1970s. And if you had told me that an AI had made it, a modern art master had made it, or one of my toddlers had made it, I wouldn't really know the difference, although that may just say more about my artistic sensibilities. But like with music, AI is getting a lot better at making art, or at least people are willing to pay a lot more for it. So a couple of years ago, Christie's had the first AI generated art, or at least it was advertised as this, sold for $432,000. And today, AI generated art exhibitions are not uncommon. If you're looking for shocking headlines in the art world, it's what people are willing to pay for NFTs, which is a whole nother subject. But a lot of NFTs are AI generated. And along with general sorts of questions about NFTs, like, is there a copyright associated with it? Of course, we have these legal questions with AI generated works, can you get protection on that sort of thing? Just as AI hasn't passed the scrutiny and attention of policymakers, nor has AI and IP passed the scrutiny and attention of government people in AI and IP. So the US Patent and Trademark Office launched a request for comment in 2019, one on AI and patents and one in AI and IP generally. It wasn't perhaps phrased that well. It was called artificial intelligence innovation, which could mean a computer implemented invention or could mean a lot of things. But one of the things they were looking at was definition, so I guess it was okay. This report came out in 2020 and said there's not much to see here, which is an interesting finding. It wasn't just AI and copyright, it's AI and patents, AI and trademarks, other things. Trademarks are interesting. Here's something that could be a trademark, and I made this in about 15 seconds before coming using brandmark.io. It's kind of misleading to say I made this at all. I typed in Atlanta IP and of court twice, picked a color palette at random, and scrolled through 50 images to find one that I kind of liked. You could say I exerted some creative control at that part of the process, but also you could have taken all 50 images and filed for copyright registration on them. So the idea that an AI makes something to which you would normally get copyright protection seems pretty clear. And here it is making something that could get trademark protection. Trademarks are a bit different in not requiring originality for the existence of one. But also AI challenges trademarks in all sorts of interesting ways people often don't think about. Like if AI is doing the shopping online, if you have Alexa or Siri doing your purchasing and you have AI listing products, how does that change trademark dynamics? What sort of competing marks would AI find confusing? Or are people designing marks to be deliberately confusing to AI? And how do human-centric standards of confusion apply when, again, all of the parties involved in this are artificial intelligence? The UK IPO launched a consultation similar to the US PTOs last year. Their report came out this year, and contrary to US PTOs, although a number of the same stakeholders and companies replied to this, the UK IPO did find that AI was challenging the IP system in some pretty fundamental ways, and that they were going to hold a consultation to figure out what exactly, if anything, should be changed. They're now in the midst of doing that. And again, not just AI making things. For example, this company Clearview develops facial recognition AI, which it licenses to law enforcement agencies largely. It has trained its AI on 10 billion photographs from the web. So it is, of course, AI getting the photographs, processing the photographs, being trained on the photographs, and whether or not that sort of thing constitutes copyright infringement, who would be liable for that, on what theory, is a host of interesting questions, and how it interacts with things like privacy laws. In Australia, they were recently found to have impermissibly engaged in this process. I think I had something else to say on that slide, but it's escaped me at the moment. Anyway, not oblivious to the jurisdictional issues at stake here, WIPO has been seeking to lead a conversation on AI and IP. It had 3 of those before rebranding it as Frontier Technologies. The 4th one was on data, and they're doing a 5th one coming up. In theory, we have a fairly globalized intellectual property system, and we might get some kind of treaty on AI and IP to harmonize that law. That's a slow process. We're probably going to have general artificial intelligence before that process is done. And WIPO is aware of that. So in the meantime, they've been largely getting member states and shareholders to speak with each other, figure out what the key issues are, agree on potential strategies, and not so much come up with a new binding instrument, at least at this point. And it involves other things too, like deep fakes and how we ought to treat those under the law and some of the ethical implications those things raise. I'd like to focus in on my personal favorite area, which is AI and patents. And the green thing on your left is a standard car suspension. And the silver thing on your right is a car suspension that was designed by an AI at Siemens. And Siemens presented this case today at the WIPO first conversation on AI and IP. And Siemens decided that this car suspension on the right had value and wanted to file for a patent on it, and found that they were unable to do so. And they were unable to do so because all of the engineers involved in this said that they hadn't done anything inventive. They said that they had an AI that optimized industrial components. They gave it publicly available information about car suspensions. They told it what they wanted in a car suspension, which was well known, and it spit out a design that was unexpected to all of them and was obviously valuable. But none of them had to do anything inventive to make the thing or to recognize its value. And so none of them were willing to say that they were patent inventors. Now, that isn't entirely German vanity. In the United States, deliberately and inaccurately listing yourself as a patent inventor is a criminal offense. And where misrepresenting inventorship isn't done in good faith, it's grounds for a patent being held at least unenforceable. Many people have claimed over the years to have AI making patentable things. Also, that patent attorneys just said, well, just list yourself. There's no requirement to mention an AI. And that is a solution to getting a patent, but not a solution perhaps to enforcing a patent if you're deposing someone listed on a patent who says, well, this really just came out of a machine, and the patent attorney said, well, just put your name on it, but I don't really even know what the thing is, and I didn't have much to do with it. So it is a short-term sort of solution. Prior to a couple of years ago, we really didn't have a lot of law on the subject of AI making patentable sorts of things, which raises some interesting questions. First, can someone like Siemens patent something like that? Two, who would be the inventor, or maybe what would be the inventor? And three, who would own the thing? Now, there are laws in a number of jurisdictions that either through statute or case law say an inventor has to be a natural person. There are also some jurisdictions that don't have those rules. Israel, for example, does not require an inventor to be disclosed in an application. Cyprus and Monaco, which are member states of the EPO, have reported they don't require an inventor to be a natural person. But most other places do at least use language that implies an inventor as a natural person. Of course, all of that, to the extent it's case law, comes from cases about whether a company could be an inventor. Because, of course, it would be easier for IBM just to say that it had invented all of its patents rather than picking individual people to put on them. But companies, by definition, have to act through human agents. And so if a company failed to list an inventor, it would deprive a person of getting acknowledged for having done inventive work. And sometimes it would deprive them of economic benefits, where that's part of their employment contract in the US or in Europe, for example, where you have statutory provisions for inventors to receive some benefits from some patents. AI, on the other hand, is different in that, at least in the sorts of cases we're talking about, it doesn't literally act through a person. On which note, there has been some controversy, and a lot less these days, given very recent advances in AI, about whether an AI could really invent something. I think that it can for the following reason. Sometimes telling someone to do something can make you an inventor, but usually not. Usually we know what our problems are. We often know what the solution is. We just have a hard time getting there. So if I'm at Pfizer and I say to a group of research scientists, go find a monoclonal antibody to treat COVID, and they do, that doesn't make me an inventor. Sometimes training an AI to solve a problem can make someone an inventor, especially if you're training an AI to solve a specific problem. But that doesn't work if you're training an AI to do something like optimize a component and licensing it to someone else. If you don't even know who's using it and for what, and you don't know the output specifically, there's no way you could have conceived of the invention, and thus there's no way that you could be an inventor, at least under US patent law. Finally, you can be an inventor by recognizing the value of something, not necessarily that it's patentable, but being the first to recognize the value of something. There's a limited amount of case law on this, and sometimes it's clear that someone qualifies for that. For example, if an AI at Pfizer said, well, here's 10 possible antibodies to treat COVID, go test them and find the best one, pretty strong claim someone's an inventor on that. If, on the other hand, an AI says, to a 99.99% certainty of the billion antibodies I've looked at, this clearly has all of the best characteristics, and here's all the data that would be needed to support a patent filing, or here's how you would run the trials to support this in silico data, which isn't rocket science. Not so clear anyone's exhibited any inventive skill with respect to that invention, and thus not so clear anyone does qualify as an inventor. That's what I was going to talk about on this slide. So we'll go past that. And I think I talked about this one too. No, I didn't. Okay, right. So a couple of years ago, not so much case law on this. Anyway, more case law on copyright though. So in 1988, the UK was the first country to statutorily provide protection for computer generated works. Those are works in which the work lacks a traditional human author, and the producer of the work is deemed to be the author, and the producer of the work is the person who undertakes to have the work created. And the work receives a shortened period of protection, 50 years, as opposed to the normal 70 years plus the life of the author. Obviously difficult to base a term of protection on a machine's life, given that machines don't die and don't live in the first place. But that's how it works there. And there's a few other jurisdictions, Commonwealth jurisdictions, Ireland, India, New Zealand, for example, that do that. Most countries don't. Some have gone the opposite way, like the United States. Since at least 1973, the US Copyright Office has had a human authorship requirement, although they didn't always call it that, which requires that to have a work have copyright, it has to have a human author. And that's a Copyright Office policy. It's not a statute. And they cite in support of this policy to the 1886 case of Burrow-Giles v. Cerrone, which involved this famous photograph of Oscar Wilde. And it was the Supreme Court case in which the Supreme Court held you could have a copyright in a photograph. In that case, the Burrow-Giles Lithographic Company said that there couldn't be an underlying infringement because you couldn't own copyright in a photograph. It was just a mechanical reproduction of a natural phenomenon. And the Supreme Court disagreed. In this case, Napoleon Cerrone had painstakingly set up this photograph, and the court held essentially that any tangible means by which an idea in the mind of an author is given expression is eligible for protection. The Copyright Office thinks that machines don't have minds or monkeys. A few years ago, this policy was almost challenged in court by PETA, of all organizations. This stemmed from a 2011 or 12 series of photographs that a crested macaque named Naruto, pictured here, took of himself, using camera equipment belonging to David Slater, who was a UK nature photographer. In an early version of events, the monkey just saw the camera there and took its own picture. In a later series of events, Mr. Slater had carefully been studying the monkeys and carefully enticed and set up the camera to get the monkey to take its own picture. But however the picture came about, this picture proved interesting to people and to have commercial value. That monkey, by the way, is not smiling at you to be friendly. Smiling is a display of aggression amongst macaques. Naruto is looking at his own reflection here and not liking the monkey that he sees. But anyway, when people started using this photograph without Mr. Slater's permission, he threatened them with copyright infringement. This was interesting enough to people that the US Copyright Office amended and renamed its human authorship requirement and now explicitly states underneath it that a photograph taken by a monkey doesn't qualify for protection. That seemed to be the end of the matter until until PETA sued on behalf of Naruto in the Ninth Circuit in California, alleging that the monkey owned the copyright and they were going to assist Naruto in bringing the case. That case was ultimately dismissed in the Court of Appeals, but not anything to do with the Copyright Office policy. It was dismissed on the basis of standing. So the Ninth Circuit said, If Congress isn't going to plainly state in the Copyright Act that monkeys have standing to sue, then monkeys don't have standing to sue. And so there we are with copyright at the moment. Similarly with patent law, one could imagine saying, well, a machine can't conceive of something, so you can't get a patent. Or perhaps a machine could conceive of something, but we decided to put this to the test. And I led a group of patent attorneys internationally in filing a test case for 2 inventions made by an AI. These inventions were filed first in the UK and in Europe, because in those jurisdictions, you don't have to disclose inventorship for 18 months. And also, you can get an early evaluation of patentability. So these patents were substantively examined by both offices and found to be new, non-obvious, and to have industrial applicability. We then corrected the inventorship to state that the AI had invented it and filed it in another 15 jurisdictions. And the reason we said that the AI invented the thing rather than a person, is functionally that it did. So disclosing that informed the public of how the invention was made. It prevents someone from taking credit for work they haven't done. So if I can get one of these DeepMind AIs to invent 10,000 new drugs, and I put my name as the inventor on all of them, I would overnight become the world's most prolific life sciences inventor. And something doesn't seem quite right about that. But the most important piece of this is that the applicant is the person who owns the machine, right? So headlines around the world like to conflate ownership and inventorship, but for those of us in patent law, most inventors don't own their patents. Most patents are in fact owned by artificial persons in the form of corporations. And it was our contention that whoever owns the AI should own its invention. The same way that if I own a 3D printer and it makes a 3D beverage container, I own the beverage container. And if I own an AI that creates a new patentable design for a beverage container, why shouldn't I own that? That is a common law rule of property ownership, sometimes called accession, which refers to ownership, claim of title of some property by virtue of owning some other property, like I own a cow, I own its calf, or I own a fruit tree, I own its fruit. How this plays out will depend on different jurisdictions. The UK and Europe denied the application after correcting the inventorship. They didn't reject it. It was denied on the basis that the formality of naming a natural person as an inventor was not complied with. It was then also denied in the US, in Germany, and in Australia. Just to give you an idea, we're running a little short on time of how an AI can invent things. We'll talk about it if people are interested later. In July, because it's kind of a long explanation, in July of this year, we got our first patent. This was issued in South Africa with the AI listed as the inventor and the owner of the AI as the owner of the patent. South Africa does not do substantive patent examination before issuance for a variety of reasons, but these patents were already substantively examined, and they do formalities examination. And everywhere these patents have been denied, it had been on a formalities basis. 3 days later, Justice Beach in the Federal Court of Australia issued a 41-page reasoned decision, essentially holding along the lines I'd suggested, that there is no prohibition on listing an AI as an inventor, and that at least in our case, the AI's owner was the person who would be entitled to that patent. This decision is now being appealed by IP Australia, which has said that they don't necessarily disagree with it, but they don't think current law supports it. Not to give the sense that all the jurisdictions around the world have suddenly come along with this. Our appeal to the Eastern District of Virginia was unsuccessful back in, I can't remember when that happened, it's blurring together, but that was unsuccessful. We are appealing this now. It is at the Federal Circuit. Our briefs are due on Monday. Essentially, this came down to whether or not the Patent Act uses terms that textually only apply to natural persons. And the Patents Act does use terms like individual, although the case law on this does not say that individual always means natural person. For example, 35 US Code 371 says whomever in referring to potential infringers, and whomever, which seems to refer to a natural person as much as individual, doesn't restrict you suing companies or governments for infringement. But anyway, our argument is that a more purposive approach to interpreting the Patent Act is required. And we will see what the Federal Circuit says. The US Patent and Trademark Office ultimately dropped the argument that a machine couldn't conceive of an invention when we argued that by filing the application, that constituted conception and reduction to practice. We somewhat recently had our appeal in the UK decided by the Court of Appeal, and the court split. Justice Burse, who is famous for, among other things, Huawei and Unwired Planet, which are SEP Fran cases, decided that there should be no prohibition on patenting this sort of thing. Justice Arnold and Justice Lang disagreed. We are appealing this to the Supreme Court, and we should know in a couple of months that is a discretionary application if they will accept it. Not all being resolved in the courts, so it is still pending in the Indian Patent Office, but the Indian Parliament did a consultation which recommended that the law be changed explicitly to provide protection for AI-generated works. I am told by people in India that will take a couple of years for anything to happen. South Korea may move a bit faster. The president recently announced that the law should accommodate protection for AI-generated inventions, so we'll see if anything interesting happens there. The application is also pending in the South Korean Patent Office. And again, AI and patents have a lot of interesting content, leaving aside AI making new stuff, including standards that apply to people who invent things. So for instance, one of the primary tests we use to decide if someone can get a patent is whether an invention would have been obvious to a person having ordinary skill in the art, which is essentially represented by an average person. As average people increasingly use AI, or average researchers increasingly use AI, this will make more obvious because it will augment the capabilities of researchers by making them more knowledgeable. It will be easier for them to look at prior art in other fields, and more sophisticated because it will facilitate or automate certain problem-solving activities that are now very difficult, like pattern recognition in large data sets, that suddenly won't be. And to the extent that in 10 or 20 years, some fields of activity may have AI being used as a primary means of solving a problem. For example, if it becomes common when we get a new infectious pathogen that Pfizer and Johnson & Johnson and GSK all go to companies like Atomwise and Helix and Benevolent AI and have AI sequence pathogens and find antibodies to treat them, or develop new vaccines based on pathogen sequences, suddenly the person having ordinary skill in the art may well be a person having ordinary skill in the art and using an AI like DABUS or DeepMinds. Or maybe if this really becomes automated, the person skilled in the art will be the machine skilled in the art. And that is going to be hugely disruptive to human inventors and patent attorneys. Not to worry, I'm sure AI could never automate patent attorney work, although it can draft patent applications, but we can talk about that later. If you think, for example, about monoclonal antibodies, which are all of the best-selling biological drugs, it's basically, artificial antibodies, which are things made by your body to target things like pathogens like COVID or cancer. There are a lot of ways your body can make an antibody, and enough practically that you have an infinite number of them and that human researchers could be busy with them forever. But in fact, a finite number, whether it's trillions or more. And it's not that hard to imagine that an AI could sequence every possible antibody and, for example, publish that online. And if that was considered an anticipatory and enabling disclosure, that might prevent any patents on antibodies, which are the foundational patent on really all patent portfolios for new biological drugs, or the ones that are antibodies. In fact, AI is now not just sequencing antibodies, but predicting things like drug-drug interactions and formulating them and repurposing existing drugs to new things. So it's really not that hard to imagine that an AI could not only sequence every possible antibody, but also publish really what it does. And that would be, again, tremendously disruptive to the life sciences industry. If you believe in the idea that we are going to get artificial general intelligence at some point, which is a machine that could complete any intellectual task a person could do, including improving its own programming, which would lead to artificial superintelligence, which is an AI that could really solve any problem, including those we don't know we have, well, everything is going to be obvious to a super intelligent artificial intelligence, which has some interesting implications, although almost everyone agrees, even those who think it's coming soon, we're a ways away from it. For those of you who aren't interested in AI and patents per se, I still think AI and IP has some really interesting kind of general concepts for us in the IP space and more generally. For example, it may be as AI makes a song that has a great deal of commercial value, historically copyright law, in continental Europe is there to protect the romantic concept of an author and human ingenuity or human creativity. Whereas in, the Anglo-Saxon, US, UK tradition, it is much more to protect the rights of investment and enterprises involved in commercializing things. You could have your cake and eat it too when Katy Perry was making music. But now maybe as we have AI doing these sorts of things, we have to ask ourselves, what is it we want out of a copyright system? And is it really all economic, or is it also about moral rights, or can we just sort of leave those by the wayside? I think this is also, speaking of the book that Ben's getting everyone, a point or a principle that applies more broadly to the law, which is AI and people already do the same sorts of things sometimes, and the law treats those activities differently based on who's engaging in the behavior. So for example, if you have a self-driving car that's driving an Uber and a person that's driving an Uber, and they strike a pedestrian exactly the same way, the self-driving car manufacturer will be liable for its harm under strict liability, probably, whereas the human driver will be liable under negligence. And it really doesn't make a lot of sense, and it has some negative sorts of implications to have these two different legal standards to the same sort of harm caused the same sort of way. Or Ben also mentioned that AI is automating in fast food restaurants. So if you have an AI that's replacing a cashier at a McDonald's, McDonald's doesn't have to make payroll contributions for that employee, which means that even if the employee and the AI are just about, equally cost effective, or even if the AI is a little more expensive, McDonald's wants to automate because it saves on taxes. And not only that, but we get almost all of our tax revenue one way or the other through labor income. So automation may also dramatically decrease the amount of tax revenue we're generating. I think as a general matter that the law should not distinguish between AI and human behavior when figuring out how to regulate a behavior so we get the best sorts of outcomes. And it is now 2:45, so I've somehow timed that without seeing a clock. And questions?
Thank you, Professor Abbott. It was very interesting. I learned a lot, and I'm also a little bit scared after listening to you. I guess that's part of the goal. I had a couple of questions come in directly to me, and so I'm going to bounce a few of them off, and I also welcome anybody else that would like to jump in. One of the observations was that most of what you focused on in the article in the book and in your presentation today was really on law, which makes sense since we're all in IP law. But given the implications of AI in areas like health, what role did the other areas like philosophy and ethics play in the advancement of AI?
Yeah, well, it's an interesting and it's a complicated question. I think ethics clearly has an important role to play. Just because something is legal to do does not mean that we should be doing it. The law sets a certain bare minimum of behavior below which we, aren't willing to tolerate something often, but beyond that, other things like ethics require companies like Google and Amazon and Tencent to be doing the right sorts of things with AI, whether that is, preventing them from engaging in antisocial sorts of biases, whether or not that does something like violate hiring laws, just because it shouldn't be done because it's morally wrong. And, ethics ties into a large number of other sorts of compliance issues, including really perceptions of brand and reputation. there are all sorts of reasons to do the right thing with AI aside from pure legal compliance. Although it is also not always so clear what doing the right thing is. And after an adverse event occurs, the market, regulators, and the public may think, well, you really screwed that up. And I think some of the way, a few years ago, everyone was into doing ethical principles of AI, which have their place, right? And now we are getting more into detailed regulations. But for those of us using these in products and services, we really need to have thoroughly thought through our use cases, how they're being developed, getting multidisciplinary teams involved with it, having appropriate oversight from management and boards and how this is being used, and thinking through all of the potential consequences of AI, even in the absence of things like the AI regulations from the European Commission. As to philosophy, I think philosophy in the form of, ethics is in a sense applied philosophy. In another sense, one could ask a very interesting question about whether or not a machine is doing something that is like a person when it invents or makes a new painting, or whether that's really very different from what a person is doing. And I tend to think from a legal perspective that really doesn't matter at all. If what we want out of a patent system is a bunch of new inventions that we think we won't get enough of without patents, then it really shouldn't matter if you have a machine, Einstein, a room full of monkeys laboring away making stuff. You just want a legal regime that promotes a socially beneficial sort of behavior.
Well, it sounds like, oh, Art, were you trying to ask a question?
No.
No. Okay. You took over the screen. I had a question come in the chat, Professor Abbott. It was, what are your thoughts on the extension of copyright protection to a painting in the style of Rembrandt created by AI shown in the short film, The Next Rembrandt? Would this be foreclosed? But what are your thoughts on that?
Well, it depends on, I suppose, a couple of things. It depends on the circumstances in which the painting was made, and it depends on the jurisdiction you're talking about. Now, the Next Rembrandt was explicitly stated to be AI generated art. There are always people involved in the process, which I think is some of the reason people are kind of talking past each other when they talk about some of these things. Because of course, there's always a person responsible for an AI making something. To me, the relevant question is there a person who did the thing that qualifies someone to be an author or an inventor, right? And so if your object as a company and a lawyer was to find a person who maybe could qualify as an author, firstly, you might be working on designing your R&D process up front to give a person more control over the process to colorably say that. And if it was after the fact, you'd really have to look at how the thing was made and see if there was someone that you could colorfully say, qualified as an author. Now, if we take their claim that there really wasn't an author at face value, then no, you can't get copyright protection in the US. Although, policymakers are discussing this. This is a policy that has never been challenged in court. And, that doesn't seem to stop people from paying a lot of money for it. But of course, that same work would be protected in the UK or some of these other jurisdictions as it is.
So any predictions on where the US is going to go with that?
I think the US is going to get on board with the importance of protecting AI generated works. And I think that this is going to become a very important issue when an AI is made, I think in the not too distant future, that can make commercially useful output, not just theoretically interesting output. And as the US is trying to be the world's hub of AI innovation and industry, I think policymakers will realize that protection is a critical element of that. I think before we figure that out, countries like China may figure it out, but we will see.
Another question that's really kind of a little bit far afield, but still related to IP was ideas from you about how the law should address inequities that surface in AI. Example that was given was racial discrimination.
Right. Well, I think that's also a complicated question. And I tend to think in a technologically neutral way. So for example, we don't normally ask questions when we're granting a patent about the ethics or morality of an invention. I think for a variety of fairly good reasons, including that's just not what patent examiners are trained to do, and they are the wrong people to do it. I think, for example, due in part to longstanding claims of discrimination, the European Commission is very against mass facial screening or things like citizen scoring, which China has started doing. But I think it's really not that the European Commission is against AI citizen scoring. It is against the concept of citizen scoring with or without AI. And so I think often the law should be, this is the sort of activity we don't want, whether you're using AI or not doing it, it's not permissible. Now, it is more challenging in the case, for example, of facial recognition, because without AI, you couldn't really do widespread, constant mass facial analysis, right? But I do think that may be an activity we are against, and it is really not, the AI per se that we are concerned about. And then again, if you have something more concrete, like you're at a business that uses AI to screen through resumes, and you're concerned it may be acting in a discriminatory fashion, there are laws that may prohibit that using AI or not. And then B, as a client, as an attorney representing a client, even if the law isn't prohibiting that, it's something you need to be aware of. It's something you need to be doing impact assessments of. It's something that you need to really make sure proactively isn't happening. And then even if it isn't illegal, if it happens, it's bad news for you for all sorts of reasons.
Right. This is an interesting question. I'll see what you have to say to this one, because it probably applies to you at some level too. Many of us are on the downward slope of our careers, and we will be retired before much of these changes occur. But what would you recommend to someone on the upward trajectory of their career, thinking about how to avoid becoming irrelevant?
Well, congratulations on retiring before the machines replace your job, take over your job. So I think that's going to be good. I don't think it's a matter, for example, of teaching lawyers to code. Those aren't our skill sets. I think, for students and junior associates looking at coming up, in an age where AI is doing more, it is a matter of understanding the technologies, what they're good for, what the limitations are, what the sorts of concerns are with these things, and realize as, personal computers and industrial machinery change the work landscape, so too will AI. AI, for example, is automating a lot of due diligence now. So, there's fewer large teams of people sitting in basements poring over boxes of stuff. I tend to think that's a good thing. No one really ever liked doing that. I certainly didn't, but it does take away some work experience from people starting out their careers and some opportunities. Similarly, because we're talking about patents, there's an application now called Specifio. If you put a claim in, it will generate an entire patent application. And it isn't replacing lawyers, but it is meaning that what may take you 10 hours now takes you 5 hours, because you have a nice draft to start with. And maybe you don't need that first or second patent prosecution year attorney. So I think, junior lawyers will need to be giving some thought to how they are going to be engaging with technology in their careers, and that it will change the nature of work in some good ways and some perhaps not so good ways. I don't know if that answered the question, but I certainly rambled for a while.
No, I think it did. And I have one last question for you, and we're going to get to the trademark now, since we've kind of hit copyright and patent matters. The question is, should companies seek trademark registration for virtual related products? For example, Nike has filed an intent to use application recently for examples for virtual shoes, such as e-gaming or tech functionality, where one can make customized shoes. The same is true for entertainment entities in the developing TV film production.
Yes, well, that is a great question, and I do not have an answer to that one, but I think it's a good question.
Jonathan, do you want to follow up, since you didn't get an answer to your question? Is there something that you could ask that Professor Abbott might be able to answer in that regard?
No, I would just say that that's certainly the latest trend. And don't believe me. Just Google Nike intent to use applications, virtual shoes. It is certainly where, as the professor noted, junior associates, mid-level associates could be extremely helpful because that is the latest, greatest, and most recent trend of what is about to happen to trademark law.
No, that's a good point. And I think indeed, not just artificial intelligence, which is again, not a new technology, but its level of usefulness and implementation is new and is going to be very disruptive. Things like distributed ledger technologies and augmented reality and virtual reality are likely to be big practice areas where we need lawyers who understand the technology enough, that they can sensibly counsel clients. And I, hear from a lot of clients, they have a very difficult time finding a lawyer who actually understands what a cryptocurrency is, whether they can do an ICO or whether they're an unlicensed security, what a smart contract is, how these sorts of things operate. And it's not a world that I inhabit too much, but, the metaverse is a fascinating new area, including for intellectual property. Although Mark Zuckerberg seems to have taken a lot of the joy out of it, I think it will take off eventually anyway.
All right, last one real quick, just personal opinion. So what area of AI are you most excited about?
For me, what I think is most interesting is that sometime in the not too distant future, AI is going to be at a commercial scale, doing creative and inventive things that only people used to do. And I think it is going to mean that we are going to live in a world with, a dramatically increased amount of socially useful output.
I just got one more, try to sneak it in. What is the best way for society to keep a safety leash on AI to prevent a runaway disaster?
Probably, what we should do to Mark Zuckerberg about Meta, but I think, it is a complicated question without a very simple answer. On some level, AI could destroy the human race, but so could someone who sets off a bunch of nuclear weapons. And, some people seem to be rushing to do that with fossil fuels. So, there are no shortage of existential threats to the human race. AI is one potential one, but again, we already have means of limiting risk from things like nuclear weapons or from AI or from, James Bond-like villains. And in part, that is through law and regulation, where we say there are some things we are not going to allow, like citizen scoring and mass facial recognition, or having lethal autonomous weapons that can do X, Y, or Z, or having lethal autonomous weapons at all. And then part of that is not just through laws and regulations, but also through corporate governance and oversight for our clients, and for, having industry norms and standards of conduct, and from public opinion driving best practices.
Well, thank you, Professor Ryan. We really enjoyed it. I learned a lot. I know that everyone that listened to you did. We appreciate you taking the time with us, and probably hit you up again as this continues, because it sounds like it's going to be something that we're going to need to be educated on and updated on a pretty regular basis. So
anytime, hopefully I get to come out to Georgia next time.
Well, that's our hope. And we'll try to order up some nice weather, or, maybe you'll even be here when the Braves are playing the World Series. You never know. So.